May it please Your Honor, Javier Anel Nandlan and team led by Senior Counsel Douglas Mendez for the applicant.
If it pleases Your Honor, Neil Boston, in association with Mr. Robinette for the respondent.
Before I commence the ruling, I would just like to, as I think I did in the last major case that we had before this court, admonish persons to be responsible. When a court gives a decision, somebody is not going to like it. And that's a fact of life for everyone who comes before the court, whether it's a major matter or a minor matter. Though anybody who comes to court, their matter is major. So I would urge that there be respect for the court, respect for the court's decision, even if one does not like the court's decision. And I especially admonish counsel on all sides to indicate to their clients that respect for the court is of paramount importance at all times. This is the ruling of the court. Introduction. National and regional elections were held on March 2nd, 2020 in Guyana. Guyana is divided into 10 electoral districts, which correspond to the 10 geographical regions. From all reports, the voting process in all 10 regions went relatively smoothly. According to the application before this court by Holidar, after the close of the poll, the returning officers of 9 of the districts, in keeping with the provisions of the Representation of People Act, Chapter 103, announced the total number of votes cast and the allocation of votes to the various political parties that contested the elections, both nationally and regionally. However, the announcement of the results for District 4, the largest district for the elections, by the first respondent returning officer was delayed. The applicant outlined the statutory procedures for ascertaining the results of the elections at each polling place or station in a district after the close of poll. This is provided for in Section 83 of the Representation of the People Act, Chapter 103. Briefly, this section provides for the count and the preparation of statements of poll. This process ends with the posting of a copy of the statement of poll in a conspicuous place outside each polling station, and the sealing of ballot boxes and the transmission of all the ballot boxes with the required contents of envelopes and packets and the statements of poll to the returning officer for the district. On completion of the process pursuant to Section 83, Section 84 of Chapter 103 provides for what happens after the ballot boxes and the envelopes, packets, and statements of poll are received by the returning officer. Section 84.1 outlines what occurs when the ballot boxes and the statements of poll arrive at the offices of each returning officer. It states, quote, "As soon as practicable after the receipt of all the ballot boxes and the envelopes and packets delivered to him in pursuance of Section 83.10, the returning officer shall, in the presence of such of the persons entitled under Section 86.1 to be present as attend, ascertain the total votes cast in favor of each list in the district by favor of the list in accordance with the statements of poll, and thereupon publicly declare the votes recorded for each list of candidates." End quote. Section 86.1 states that the persons who are entitled to be present are the returning officer, elections officers, members of the Guyana Elections Commission, duly appointed candidates, counting agents, and others with good reason to be present. In the context of these elections, the latter group would include local, diplomatic, and foreign observers. Election officer, as defined in Section 2 of Chapter 103, means Chief Elections Officer, Deputy Chief Elections Officer, a returning officer, a deputy returning officer, an election clerk, a presiding officer, an assisting presiding officer, and a poll clerk. In simple terms, The major complaint of the applicant is that the first respondent returning officer for District 4 has not complied with Section 84, in that having not completed the addition of all the statements of poll in the presence of persons entitled to be there, or a purported declaration was made of the total votes cast, that is, the results of the elections for District 4. As a result, in brief, the applicant seeks the following declarations: that the purported declaration is in breach of Chapter 103 and is unconstitutional and of no effect. 2, that GECOM elections pursuant to Section 96 of Chapter 104. 3, that GECOM cannot lawfully or constitutionally declare the results of the elections unless and until the returning officer or deputy returning officer of District 4 and or the chief elections officer complies with and ensures compliance with the provisions of Section 84 of Chapter 103. And 4, an order vacating, revoking, setting aside, and or declaring invalid the purported declaration made by the returning officer of the votes for District 4. Injunctions were sought and granted pursuant to an oral application made before Justice Singh on March 5, 2020. These injunctions restrained the returning officer, the chief elections officer, and the GECOM from declaring the votes for District 4 without complying with Section 84, and restrained These injunctions restrained the returning officer, the chief elections officer, and the GECOM from declaring the votes for District 4 without complying with Section 84, and restrained GECOM from declaring the total number of valid votes cast for each political party until the returning officer and or the chief elections officer complies with and ensures compliance with the provision, letter, and spirit of Section 84 of Chapter 103. A mandatory injunction was also granted, compelling the returning officer, the chief elections officer, and GECOM to comply with the letter and spirit of Section 84 of Chapter 103 and forthwith declare the votes for the political parties for the district. The application was filed on March the 6th. I should add, directions were given for the filing of the application in support of the application for injunctions. The application was filed on March 6, 2020 and fixed for hearing on March 7, 2020 due to the urgency of the circumstances. Mr. Boston, Senior Counsel, appearing for the respondents, raised the point in limine, contending that this court has no jurisdiction to grant the application and order sought, and that the injunctions were improperly granted as the issues raised by the applicant belong to a class of questions covered by Article 163(1) of the Constitution of Guyana. Article 163 provides for a determination of questions as to membership and elections. It was submitted that since this is the case, only the special jurisdiction of the court will be invoked, so that any challenge to the elections must be presented by an elections petition. It was further submitted that the court has no jurisdiction to grant injunctions by way of equitable relief, so as to restrain the conduct of elections or the conduct of elections in a particular way. The respondent's contentions. Mr. Boston referred to the claims in the affidavits in support of the application, particularly those in the affidavits in support deposed to by the applicant and Ms. Bragg. He said that these affidavits state that tabulation was being done in the presence of observers, but this verification process of the votes cast for District 4 was not completed. That verification was being done from a spreadsheet instead of from statements of poll, which spreadsheet disclosed discrepancies, and there was protest against this. that statements of poll from 500 plus polling stations are still to be tabulated in the presence of persons entitled to be there, and that there was an attempted declaration or declaration without verification of these remaining statements of poll, that there was no proper or lawful declaration of the votes for elections in District 4 in compliance with the provisions of Chapter 103. Given this fact scenario, it was submitted that the applicant is contending that there has been an unlawful act or omission which affects the results of the election, so any challenge falls to be determined pursuant to Article 163(1) of the Constitution. Mr. Boston specifically relied on Article 163(1)(bi), which provides, subject to the provisions of this article, the High Court shall have exclusive jurisdiction to determine any question whether either generally or in a particular place an election has been lawfully conducted or the result thereof has been or may have been affected by any unlawful act or omission. It was further submitted that Article 163(4) states that Parliament is to make provision for proceedings by which any person under Article 163 may be instituted in the High Court. In this regard, Parliament passed the National Assembly Validity of Elections Act, Chapter 104. Section 3 of Chapter 104 states that the questions referred to in Article 163(1) are to be commenced by elections petition. The Act sets out a procedure for the filing of an elections petition which, pursuant to Section 5, shall be presented within 28 days after the results of the election have been published in the Gazette. So it is contended any challenge which must be by way of petition can only come after results of the election. A leading Guyanese authority of Gladys Petrie and others, and the Attorney General and others, 1968, 14 Western Reports 292, and the authorities cited therein were referred to extensively, as well as C. Kumar Singh and another and Butler, 1973, 21 Western Reports 34, which followed Petrie. Raman, the Attorney General, 2019 CCJ 10AJ was also cited, but I do not consider that it is applicable, given the vast differences in factual context. In Petrie, there was a challenge by way of summons for a declaration as to the validity of certain laws regulating elections and for interlocutory orders against the Elections Commission and the Chief Elections Officer. After consideration of a number of authorities, Chief Justice Wallace held that the proceedings should have been commenced by way of elections petition, and that the plaintiffs were not entitled to an injunction, as this would have negated Article 67 of the Constitution, under which the Governor General had appointed the elections day. It was held that the plaintiff's application fell within the class of questions to be determined by Article 71 of the Constitution, which is now Article 163, so that such matters had to be raised by way of elections petition after the result of the elections had been known. Mr. Boston submitted that when one looks at the elections laws as outlined in the Constitution, Chapter 103 and Chapter 104, they do not contemplate two attacks on elections, one by way of judicial review while elections are ongoing, and another after they have been completed by an elections petition. This is to say, the law does not contemplate a two-stage process. Mr. Boston summarized that since the applicant is saying the acts and omissions to verify the statements of poll from the 500 plus polling stations in their presence is a specific illegality and it affects the outcome of the elections, and since the basis of the contention is that the process is not being done in accordance with the elections laws, they cannot come to this court by this application if the process has not been complied with. They are not without redress in that they can file an elections petition and there produce elections documents and evidence in support of the petition. Applicant's response. Mr. Mendes' senior counsel submitted that the issue raised by the respondents is whether the matters which the applicant has raised fall within the class of questions which the legislature has said can only be brought by an elections petition after the elections have concluded, that is after government has already been installed. Mr. Mendes contended that the preliminary point has no merit because the issues raised do not fall within the class of questions contemplated by Article 1631BI. This is so because they do not challenge the results of the elections as they are not known. They do not challenge the elections themselves. The application seeks to facilitate the election in accordance with the law, irrespective of what the results might be. The factor matrix relied on in the main is that there were 879 polling stations for District 4. 421 statements of poll have been dealt with by adding figures, with there being minor discrepancies which were resolved pursuant to Section 841A. The problem is in relation to 458 polling stations, as the process for tabulating the statements of poll was suspended. Despite this, a declaration was apparently made by the first respondent under Section 841. The court is being asked to order that the process be followed pursuant to Section 841, more especially as the transparency of elections requires that it be done. The orders being asked for are geared towards facilitating a proper process, whatever the result might be. It was submitted that Mr. Ramsey, on behalf of the PPPC, made a request for a final count under Section 842, which would mean that a declaration cannot be made as counting of the ballots would be necessary. There is an affidavit to this effect and a deposition that he was not recognized as a counting agent of the PPPC. Sections 83 and 84 were reviewed by Mr. Mendes. That is of chapter 103. It was also submitted that although Article 1631 says that the High Court is to determine questions regarding elections, it does not say how, but that pursuant to the Constitution, Parliament enacted Chapter 104. It was advanced that this ordinary act cannot oust the jurisdiction of the court in its supervisory jurisdiction, and that the court should lean to maintaining the court's supervisory jurisdiction. He referred to the National Assembly validity of election rules annexed to Chapter 104, more specifically Rule 3, which he said limits what can be brought by an elections petition. The question which this rule specifies that is relevant to this case is, quote, whether the result of the election may have or has been affected by any unlawful act or omission, end quote. However, the claims made by the applicant do not fall within this category, as the results of the elections have not been declared. The cases of Election Commission of India through Secretary and Ashok Kumar and others, a decision of the Supreme Court of India dated 30th of August 2000, in the matter of an application by Aubrey Norton for writs of certiorari and prohibition, 1996 to 1998, Guyana Law Reports 373, and Joseph Hamilton and the Guyana Elections Commission by Judicial and Attorney General, Motion 40M of 2001 were relied on. It was reiterated that the application does not speak to the validity of the elections. It seeks to ensure that election officials perform their duties. The evidence is that the returning officer is deliberately flouting Section 84, and it cannot be, as submitted on behalf of the respondents, that one must await an elections petition. It was finally submitted that, as has been advanced on behalf It was finally submitted that what has been advanced on behalf of the respondents is a purely technical jurisdictional point. The statutory provisions must be interpreted in favor of the court carrying out its supervisory duty, and that Chief Justice Bernard has pointed the way forward on this issue in Hamilton. Mr. Boston reply submitted that Hamilton is wrongly decided, as it introduces a two-part process which the provisions for challenging elections do not contemplate. He reiterated his contentions, citing a 2019 case from India of Dr. S. Pandey and the Chief Electoral Officer, Tamil Nadu Public Elections Department and others, dated the 5th of April 2019. Analysis. There are aspects of the claims in this application, whether Mr. Ramsey was recognized as a counting agent for the PPPC, whether an application for a final count for District 4 was accepted or not, and whether what the applicant says are statements of poll he has in his possession have correct tabulations which are not for an application such as this. My initial view on these issues is that they would be better canvassed in an elections petition. Thus, out of an abundance of caution, I do not rely on any of this evidence in coming to a decision in this ruling. However, having reviewed the applications, submissions, and authorities cited, I have concluded that this court has jurisdiction to hear this application as regards whether the first respondent returning officer has complied with Section 84 of Chapter 103. The first respondent is returning officer for District 4 is a person exercising statutory authority, more specifically in this case under Section 84. There is prima facie evidence that there has been non-compliance with the process outlined in Section 84.1. While Petrie, Sikumar, and Palpandi confirm that elections petitions are the stated procedure for challenges to elections, which process encompasses the time the elections process starts with the proclamation to the declaration of the final results, it is equally clear from Kumar, Norton, and Hamilton, from the Kumar, Norton, Hamilton decisions, that where an election official has not followed the process as outlined in the relevant statute, in this case Chapter 103, before the final declaration, that such failure is open to judicial review. This is a case where the actions of the returning officer in complying with Section 84 of Chapter 103 are up for review. There is prima facie evidence in the affidavits. The caveats are referred to earlier that permits the hearing of this application. In Hamilton, the complaint was in relation to non-compliance with the said Section 84 of Chapter 103 by the then Chief Elections Officer. Chief Justice Bernard reiterated that it is pellucidly clear that the validity of the results of an election can only be challenged by the filing of an elections petition. However, in granting the order sought, the CEO comply without delay with Section 84, Her Honor noted at page 18 that the applicant's complaint was not about the validity of the elections and that what he sought was compliance by the CEO with his statutory duties. The situation is no different as disclosed in the prima facie evidence in the affidavits of the applicant and Ms. Parad. The Hamilton case clearly contemplates judicial review of actions or decisions made by elections officers made during the process of the elections. In the Norton case, Chief Justice Bernard held that but for the specific ouster of the court's jurisdiction to question the decision of the chairperson of the Elections Commission to declare the presidency pursuant to Article 177(6) of the Constitution, the court had jurisdiction to order certiorari against the decisions of the Commission and its chairman. Again, Chief Justice Bernard clearly emphasized that the court can exercise a supervisory jurisdiction in elections cases outside a challenge to the validity of the elections by way of elections petition. In Kumar, the Supreme Court of India emphasized the provisions that require challenges by elections petition, noting that this is the procedure when the question posed would obstruct or interrupt the election process. It referred to the avoidance of the two-pronged attack which Mr. Boston emphasized. But the court equally noted that there are situations which would call for the intervention of the court in its supervisory jurisdiction. I adopt the dicta in Kumar that this is a case where the challenge is meant to, quote, accelerate the completion of the election and acts in furtherance of the election, end quote. It was further noted in Kumar that, quote, a dispute raised may not amount to calling in question an election if it subserves the progress of the election and facilitates the completion of the election, end quote. It was also stated in Kumar that there may be cases where the relief sought for may not interfere or intermeddle with the process of the election, but the jurisdiction of the court is sought to be invoked for correcting the process of election, taking care of such aberrations as can be taken care of only at that moment, failing which the flowing stream of election process may either stop or break its bounds and spill over. The Supreme Court finally held thus: without interrupting, obstructing, or delaying the progress of the elections proceedings, judicial intervention is available if assistance of the court has been sought for merely to correct or smoothen the progress of the election proceedings to remove obstacles therein, and the stage is set for invoking the jurisdiction of the court. I am therefore cognizant of the restrictions that require the approach to the court by way of elections petition. However, there can clearly be cases where the court's supervisory jurisdiction can be invoked to ensure the correct and smooth operation or progress of the elections proceedings or process. A court cannot shirk its duty in this regard and shelter behind the contention that an elections petition should be filed when the case clearly does not so warrant. As such, having found that there is prima facie evidence to support the court having jurisdiction to hear this application, the respondents must be given a chance to be heard in response through any evidence they may wish to file. Mr. Boston.
Defense.
Yes, it will be in defense. It was a fixed date application. Yes.
Give us.
You have until 9:30 on Tuesday morning.
I was thinking about 2 days.
No, Mr. Boston. 9:30 on Tuesday morning. Court will convene at 10 o'clock. I don't see how you could request 3 days, Mr. Boston, in the context of the nature of the case. As it is, when I saw the order in which the applicant asked for 3 days to file, I was astounded. So it cuts both ways. So permission to respondents to file affidavits in defense before 9:30 a.m. on Tuesday, March 10. So the holiday comes in handy, Mr. Boston.
Do you wish to put it down to 10:30?
Put what down to 10:30?
Filing by 10:30 on Tuesday.
All right, I'll give you the extra time. All right, well then I'll put this for 1 o'clock because I will have to read whatever you file. Yes, Mr. Mendes.
Milady, two things arising out of that. In the event that we need to reply, would you make some provision for that? Lady, in order not to disturb the 1 o'clock fixture, if it is possible to ask my little friend to go back to the 9:30, if we are served by 10, then if there's anything to respond to, we'll certainly attempt to do so before 1 p.m. But if, so I appreciate the need, Lady, for speed, and therefore I would ask you to go back to the 9:30, and then we will be able to respond before 1 o'clock.
Mr. Boston, let's get some negotiation.
If he pleases, Milady, we will attempt to get our responses before 1. Or if Milady would prefer to sit at 2, it will give us a little bit more time. Either way, Milady.
All right, I know what I do. It kind of like helps me because I have a number of matters in the morning.
Of course, Milady.
That will help to clear those out. I do have one in the afternoon, which I can fix. So, all right, you'll get up to 1:30. Should we reply if necessary? Because if it's on legal points,
Of
please
course,
don't
we do.
file.
Of course, we only deal with any factual situations that need to be addressed.
Or we're going to have to work a little late on Tuesday. So I'll adjourn to 3 o'clock on Tuesday afternoon. Very well. Thank you very much. Sorry?
Unfortunately, there's another matter that I need to bring to your attention. First of all, if I gather we were in a case management phase just a moment ago. And of course, the rules provide that at a case management conference, the parties must be present. And that would include the Chief Elections Officer ought to be present as a mandatory requirement. And I'm bringing that to your attention because of certain events that occurred since the hearing yesterday. And those events included or began with an email written by Mr. Lowenfield, Chief Elections Officer. My little friend has a copy of it, and I'll pass it up to you, my lady. Act, and you will recall, my lady, that is the section under which the Commission, or by which the Commission publishes the results of the election in the Gazette. Just to remind you of the wording, it says, as soon as practicable, but not later than 15 days before after the election, the Commission shall publicly declare the results of the election and shall cause to be published in the Gazette a notification thereof specifying the number of votes cast for each list of candidates. So what Mr. Lowenfield is saying there is prepared a report for those purposes, which one would assume would therefore contain a declaration of the number of votes cast for each list. Now the order by which Mr. Lowenfield was bound, and you'll recall, my learned friend, Mr. Boston yesterday was about to read out the order to you, and you told him it's not necessary because you had a copy of the order. And that order says, in the very first one, the one that he was about to read, that an injunction is hereby granted restraining the returning officer, Mr. Mingo, the Chief Election Officer, Mr. Lowenfield, and the Guyana's Election Commission jointly and severally by themselves over the agents, etc., from in any manner whatsoever declaring the votes recorded for each list of candidates for the said district before complying, etc., with Section 84. So what he has done, in accordance as evidenced by that email, is that he has prepared a document for the purposes of Section 99, which one would have to infer includes the very thing that he was prohibited from doing by this order. What is egregious about that, my lady, is as Mr. Lowenfield's lawyer was seeking to have that injunction discharged against him on the basis that the court had no jurisdiction. Mr. Lowenfield, a couple hours later, after you rose to consider your decision, committed what appears to be a violation of the order. We simply seek at this stage, my lady, that report, that final report that he refers to, be revoked, be formally revoked, and therefore play no part in these proceedings whatsoever going forward. And I say this, my lady, without prejudice to any application for contempt that might be made at a later date. I want to make it clear that it is without prejudice. But certainly, my lady, this court, I would urge this court not to countenance the flouting of its orders, particularly while proceedings are under consideration.
Yes, Mr. Boston, what do you have to say to this?
Now, this declaration was made, the order was made after Mr. Lowenfield has made his declaration, but
No, Mr. Boston, just a minute.
no, I'm not
Mr.
condoning
Boston.
that. I just wish to.
No, you've gone to, I'm sorry, I think when you say after Mr. Lowenfield has made his declaration, Mr. Lowenfield made a declaration before the order. What declaration was that?
The results.
Of what?
No,
No, the results of what?
from 9 regions. But let us not go
Okay,
there.
so that's 9
No.
regions, so the issue is 10, the 10th.
No, let us not go there. Miss Ward has circulated a letter. My learned friend did not read the content of that letter.
Who is Miss Ward?
I think she is the PRO. There is this press release. She has explained the position there quite clearly, that the Commission has no intention to act unlawfully. And you can see this release is dated the 8th of March, today. So they have no intention of condoning any wrongdoing or breaching the order of justice of Injuction.
Very well. We'll hold you to that, Mr. Boston.
Certainly.
Lady, we were not surprised that the Commission, headed by a former judge, would issue this statement guaranteeing to the court that the Commission would abide by the orders of the court. We are not surprised by this at all. But we are not talking about a violation by the Commission. We are talking about a violation by Mr. Lowenfield himself. The Commission, there's nothing to indicate that the Commission asked for this report on the part of Mr. Lowenfield, and therefore we are to presume that Mr. Lowenfield produced it all on his own, because he's writing to the chair asking for a meeting at which he can present this report, and then the chair responds assuring the court and the public generally that that meeting will not be held, certainly not while these proceedings are extant. And we are grateful but not surprised that the Commission, headed by a former judge, would issue such a statement. We are concerned with Mr. Lowenfield's actions. We are concerned with this report, what he refers to as a final report that he has produced, which would contain the very information that he was prohibited from producing. And we are asking that that report be revoked and not play any part in these proceedings going forward.
Well, Mr. Boston, I would urge you to ensure that your clients abide by the order.
Yes,
all of them.
I'm giving that undertaking.
I'm much obliged to Melody.
Very well, so we'll adjourn to March the 10th.
Last thing, Melody, just to be clear, Melody, the injunctions of course continue.
Well, actually, the injunctions of themselves are not interim. That's a whole other issue, but
But could you append onto it pending the determination of the proceeding?
sorry?
Could you amend it by saying pending the determination of the claim? I understand what you're saying, Milady. So that I noticed myself that
That they
didn't
were.
say pending. Yes.
I have some difficulty whether you can do that in these circumstances.
It doesn't matter because pending the hearing, actually right now the injunctions appear to be absolute. So
Yes,
the intervention by Mr. Mendes was just making them interim, but they can remain as they are then. Thank you very much.
Much obliged.
March the 10th at 3 o'clock. Thank you.
The returning officer for representing the returning officer and the chief elections officer, along with the Guyana Elections Commission, speaking to the media there, outlining what the Chief Justice has said, which is that she does have jurisdiction for this case. The matter of an elections petition does not arise because the results of these elections have not been declared. You will recall that last evening the Chief Elections Officer said he had prepared a final report on the vote count in all 10 regions, but she has admonished Mr. Boston to ensure that his clients comply with the injunction that have been granted by the High Court, which is that there could be no declaration of the elections results until the process of verification in region number 4 is completed. She ruled that a prima facie case has been made out that suggested a prima facie case has been made out suggest
Dr. Yogi, you're live.
So again, it's a bit difficult to get through the crowd
we're
of
live. We are going to
the
continue
media
to connect with the
here
folks on the ground to get
to
the
speak
various
directly
interviews going
with
on with
Mr.
Boston
Boston.
et al. Yeah. Good day to one and all. The decision of the Chief Justice, Madam Roxanne George, has just been handed down, but we'll try to cut into the interviews to the ground.
Doctor, 1 second, right? We're gonna switch to you
Again, we're
back
reporting
now.
from the High Court,
When you see
where
yourself on the screen, then you're live, okay?
Okay.
the Chief Justice, Roxanne George, has ruled that she does have jurisdiction, or she does have power to hear the case brought before her, challenging the report made by the returning officer.
Doctor, you're live now.
So we are live, coming to you, assessing the decision of the Chief Justice that has just been handed down. Viewers, please bear with us as we try to cut back and forth into what's happening at the scene around the High Courts, the interviews that will be taking place with various persons. The interviews going on the ground, we'll try to intersect our program with having live feeds of persons being spoken to. To our viewers out there, reminded that we have the decision of the Chief Justice, which she has decided that the court has jurisdiction and will hear the matter in front of it. Judicial review of the process is allowed. We expect to be joined by some guests, and our technical operator, Devin Bissoon, is working hard behind the scenes to ensure that we can intersect our program with various legal opinion coming from various personnel, both on the ground and in various places across the country and, of course, in the Caribbean. Viewers, a very, well, first of all, let me say Happy International Women's Day to one and all. It's a phenomenal day of beautiful weather in Guyana. Just now we have had a decision from Chief Justice, Madam Roxanne George, who declared that in her opinion, the court has jurisdiction. Let's listen into some of the interviews going on the ground.
Boston.
We will invite him to come. The law, the rules of the court provide that during case management proceedings, the client must be in attendance.
What do you make?
But we have gone past case management. But we had no case management proceeding. None whatsoever.
What do you make of GECOM's statement today?
What do I make of
the
GECOM's
GECOM statement
statement
today?
today? I don't think it was deliberately meant to flout the order of the court. It was directed entirely to the chairperson so she can summon a meeting with the members of the commission to discuss the results from the 10 regions with a view to make a declaration if these injunctions had gone today.
Mr. Watson, if you don't get a ruling favorable to you, do you plan to take this for a higher court?
Entirely to the chairperson so she can summon a meeting with the members of the commission.
To a higher court?
We are going to consider that when we go back to our office.
Thanks a lot, sir.
Thank you.
So reporters are now speaking with Mr. Anil Nandla, one of the attorneys.
Doctor, you can
You can continue.
All right, we are back live again. So viewers out there and across the world, yes, we have the decision that has been handed down by the Chief Justice. We're gonna go on and off. Sorry about that, viewers. We are getting trying to connect with the viewers. We are trying to connect with a number of persons on the ground. So my apologies for the little back and forth we're getting. However, we are here. We're going to be running a program here to discuss the hearing, to discuss the decision of Madam Chief Justice Roxanne George. Let me say to you all that, let me repeat, and I'll keep on repeating this, I guess, so that we all understand what is going on the ground. Madam Chief Justice Roxanne George has handed down her decision that the court has jurisdiction and will hear the matters in front of it. What she has also determined as well is that judicial review of the process is allowed. Judicial review of the process is certainly allowed. The court will reconvene on Tuesday, and in its in their deliberation today, the court was asked by Mendez, Counsel Mendez, who appeared on behalf of the PPPC. Mendez reminded the court that notwithstanding the matter that was in front of the court, let's go over to Anil Nandalal, who is live presently. We'll come back to our show.
Ready to reply to him before 1:30, so that at 2 o'clock, our affidavit.
But sir, you know there's that 15-day period by which GECOM must hand in those results. What happens if this stretches and threatens that period?
The court will take that into account, and we are aware of that. I'm sure that the Chief Justice is aware of that. Hence her putting this matter down so early and her expressed intention of concluding it at the earliest possible time.
She did mention that some of the arguments might best be suited too for an election petition. How do you respond to that?
Some of what arguments?
That were put forward there today.
Yesterday.
Yesterday.
Well,
some things requested.
Well, once the court has jurisdiction to determine the issue that we have raised, which is a narrow issue, whether or not Mingo should have complied with Section 84. Does the court have jurisdiction to determine that issue? The court said yes. And the Chief Justice said that the order will remain in place. The injunctions are going to remain in place. So obviously, whatever is beyond the jurisdiction of the court will not hear it. But the court has pronounced that it has the jurisdiction to hear and determine the relevant issues. And that is whether or not Section 84 should be complied with, whether the verification exercise should be done. That's important.
Mr. Nandalal, Mr. Lowenfield has a communique that says that he has completed his work and so on, and is asking the chairman. Do you know the contents of that communication?
It is public. It is public, please. So that's what I have.
That is from Mr. Nandalal.
So we're going to try to get some interviews there, but we heard from both sides. Mr. Schumann?
It seems like Mr. Mendez and Mr. Nandalal are in the Chief Justice's chamber.
I'm going to try to get a comment.
Today, the Chief Justice ruled that the court has jurisdiction to hear the orders. What do you make of the court having jurisdiction to hear the orders today?
Good afternoon. I think that the court has ruled, has made a ruling, and I am happy with the ruling at this point because based on the numbers that we would have gotten from the field, is that the numbers that were presented by the CEO or what seem to have been published are inaccurate. And I think the only way to ensure the accuracy of that information is for all of us to go through and comply with what Section 84 of the Act says.
So where did your party get its SOPs from?
Our party's SOPs were actually generated from the fields. We have agents in the fields also.
How many SOPs you have in your possession?
I cannot say. I'd have to go back and visit our team and see those SOPs.
Is it hundreds?
Where did you see discrepancy?
We don't have the capacity to look at all of the SOPs. We don't have 2,300 and change polling agents, but we do have enough to at least verify in some parts of the country what's contained in those SOPs.
But in Region 4, how many do you have in Region 4?
In Region 4, well, we rely on our partners within TNM, ANOG, and even in some cases, the other parties that did not contest across the country, we rely on those. There's a reason why we have a joiner list, so that we are going to utilize that in this case.
Did you receive any from the People's Progressive Party Civic?
I have not been in receipt of the PPP's SOPs.
They have not given you any? No copies?
I have not received SOPs from the PPP Civic. I don't know how much clearer I can make that one.
Thank you. There is Mr. Schuman of the Liberty and Justice Party. The Chief Justice has ruled that the court has the jurisdiction to hear the injunctions and the order, and the matter continues on March 10th at 3.
And hopefully they come to tell us what's going on. We see some of the folks from ANA coming here. Let's hear what Mr. Jonas has to say.
Mr. Jonas, what do you make of today's ruling?
We have had a decision from the Chief Justice that is in accordance with the Hamilton case. Now, the Hamilton case was argued nearly 20 years ago. And in the Hamilton case, the PPP tried to avoid the need to count the statements as full. And the PPP took a preliminary objection in court that the court had no jurisdiction and that everybody had to wait for the illegality to take its normal course, and then after the new government was sworn in, then to file an election petition. Now we have, having had the 6, we have the half a dozen. The shoe is on the other foot. The same lawyers who argued the Hamilton case now come with a straight face and argue exactly the opposite.
They were saying it was different.
I'm not speaking to you.
We may not speaking to me. I'm saying they were saying they're different.
Can you put your cameras on this gentleman, please? Please put your cameras on this.
Are you threatening them with journalists?
Mr. Jonas, he happens to be a
I'm not afraid of you either.
Mr. Journalist, you're Mr.
Mr. Mosley has demonstrated a bias, has
Which bias is
demonstrated a
that?
partiality. And therefore, I'm afraid I'm not willing to answer Mr. Mosley. And I will ask him not to ask me any more questions. I'm happy to answer questions from the independent press.
And I'm independent, so you'll answer the question if you choose not to
Mr.
answer.
Jonas,
Yes, sir.
you were explaining.
Yes. So we now have a situation where lawyers who argued one way more than 10 years ago have now come to the court with a straight face to argue the exact opposite. And those same lawyers who benefited from the Hamilton decision have now said to the court, oh, the Hamilton decision was badly given. The Chief Justice has given what, in my respectful view, is the correct decision. She has said she has jurisdiction because we are at a stage where a specific illegality was alleged, a specific non-conformity with Section 84 was alleged, that where Mr. Mingo was required to ascertain count by using the statements of poll in the presence of those people who were entitled to be there, he entirely avoided that process and unilaterally announced a result which nobody knows about and nobody can confirm. Now, our process must be transparent, and Section 84 is designed for transparency. So that specific illegality, if proved, vitiates what he did. And the Learned Chief Justice found there was sufficient prima facie evidence to warrant the continuation of the injunction and gave the parties leave to put in their affidavit, and we will see what Mr. Mingo says in his
Are you more comfortable now than earlier than last week when all of this started?
I'm going to stick my neck out
Or
and I'm going to make a statement about the court. I believe this is the best Chief Justice Guyana has had in my years of practice. She has demonstrated that she is impartial, she has demonstrated that she's professional, and I have every confidence in her.
Could you say where your party got its SOPs from? Could you say where your party got its SOPs from?
I'm sorry, what did you say?
Today we have Jonas not wanting to answer that particular question.
I'm sorry, I didn't hear you.
Whatever decision she makes next week, you'll accept.
Oh, we will absolutely respect the decision of the court. If we don't like it, there's a procedure that you appeal.
Could you say where your party got its SOPs from, sir?
Are you concerned though that the interim, the political directorate may in fact want to flex his muscles and have the president sworn in, notwithstanding the assurances given today in the court?
Well, Mr. Boston gave an assurance. I understand that in Starbuck News there is actually a publication by GECOM, and I haven't personally seen it, but I would like to go and see that publication to see if it conforms with the undertaking that Mr. Boston has given. Right now, the orders that exist in court prevent GECOM from continuing. Justice Claudette Singh is a past judge of this court. I would be surprised if she takes it upon herself to ignore the order that has been made. She has, in writing, in a letter that was shown to the court just now, said that she will not proceed, she will not convene GECOM in order to receive the report of Mr. Lowenfield, and I have every hope that she will honor that.
I think that was a press statement, not a letter.
Yes.
I saw a letter.
So could you say where your party got its SOPs from?
Would you say this is a right step towards a free, fair, and democratic election?
Who's you? I don't understand. You remember the press?
You prefer to speak to him. But could you say where your party got its SOPs from?
Are there any more questions?
Yeah, Mr.
Not
Jonas,
from
Where did you get the party
as
SOPs
a
from?
part of the proceedings, have you ever sought to apply to be a part of the proceedings?
Oh no, we have not applied to be part.
Mr. Jonas,
Oh,
does your
your
party
party
have
is to
SOPs to
verify
cover
the
all the stations in Region 4?
I'm sorry,
Does your party have all SOPs to cover for Region 4?
Okay, now that you have asked that, I will answer the question. This is the point that this is the poison that Mr. Mosley has been trying to
I asked a question on social media.
And if you will allow me, I will answer it. I want to present you with a situation. First of all, I will answer your question directly. These small parties are of limited resources and absolutely not, we certainly did not have a presence in each polling station so as to receive a statement of poll from each polling station. But the point that I wish to make to you is that if GECOM is obligated to ascertain, if Mingo is obligated to ascertain 400 odd statements of poll by holding them up in the presence of all the people who are entitled to see them and counting them and tabulating them, and a new and united Guyana has, by its limited resources, gotten 10 or 20 of those statements of poll. Not all 400, 10 or 20. Mr. Mingo doesn't know which 10 or 20 we have. So we can sit down, and when he reaches the one that we have, we can say this accords or does not accord with what we have. And therefore, if when he has completed, his process accords with even those 10 that we have, as he has passed them, that gives me comfort. So the red herring that Mr. Mosley has raised and that he is trying to rabble-rouse about is a red herring.
I asked a question and you chose to answer the question. Don't be disrespectful to me. Catch yourself.
Your anecdotal.
No, I understand the good faith of that question, but every international observer, every local observer, private sector commission, CARICOM, everybody has said no one knows the result until Mr. Mingo stands up, does his job honestly and ethically, counts the statements of poll in the presence of the people entitled, and makes an announcement.
Could you say what caused the disruption of that
until that
process
is
of
done,
verification?
I am not going to make a
What
statement
caused the
about,
disruption
let me finish that question, please. Can I finish that question? Thank you. I am not going to make any statement about what I think should happen or ought to happen or who won or who or how many seats which party got, because that process needs to be respected. Mr. Mingo has not respected the process.
But was he allowed to do the
disruption of that process of verification?
That's a good question. Now, at the time, and I was in the building and I can tell you, the people who were entitled to be present were sitting in the room. The statements of poll had been collated and were there to be ascertained by Mr. Mingo. We were sitting in the room in the Region 4 office, which, as you know, is Ashman's building. Those statements of poll remained untouched when Mr. Mingo went to make his statement, when he went to make his declaration. So I am telling you that Mr. Mingo did not ascertain from the statements of poll and tabulate the count at the time he made his declaration, because those statements of poll that GECOM had and should have been ascertained by Mr. Mingo were sitting untouched for the most part at the time he made
Have you and your parties collaborated to ensure that there is proper security of all of the documents that were in the Region 4 District Office up to the time that that declaration was made or purportedly made and now?
Well, up to the time the declaration was made, everyone was looking at the statements of poll. They were physically there in the room. Unfortunately, after the declaration was made, we milled about. We know we couldn't leave them. And you will remember, I'm sure you will remember the news. First of all, Foreign Affairs Minister Cummings turned up, who had no jurisdiction and no right to be there, to threaten to revoke the accreditation of the international observers, which he hadn't given in the first place, because that accreditation must be from GECOM, since GECOM is the autonomous body authorized to do it. When her attempt failed, there was a bomb scare. Now, I hope at some point we examine and find out who received this bomb scare, whether it was by phone call, whether it was by letter, whether it was in person, who reported it to the authorities. I hope that is examined, because it will not be the bomb scare you must leave. And the United Guyana representative.
The lawyers for both parties are heading into the Chief Justice's chambers.
That we will sit in this building and take the risk of being blown up with a bomb, because we have to look at those statements of poll that Mr. Mingo has to ascertain. After the bomb scare, we milled about, we sat down, we watched the statements of poll. Mr. Mingo made his announcement without touching the statements of poll, and we could do nothing, but we had to watch the statements of poll. Eventually, between 7:30 and 8 o'clock that evening, the police came in and they insisted and cleared the building and locked it. Now, again, I hope at some point there's an investigation as to who instructed the police that they were authorized to go and remove accredited observers, party representatives from that building, so that it was no longer possible to keep visual contact of the statements of poll. And to answer your question, Dennis, your guess is as good as mine as to what happened to those statements of poll. I hope that GECOM, in whom we all have absolute confidence, continues to keep them safe.
So, Mr. Jones, unless I was just dispatched by the Chief CEO, Mr. Lowenfield, that he has completed his work and he's asking the chairman to have a meeting with him. What is your take on that?
One more time, please.
That letter implies that Mr. Lowenfield has accepted the declaration by Mingo and has therefore stated and is ready to make his announcement to GECOM. Now, that would have been impossible for Mr. Lowenfield to have done in the time frame between the time he got the order and the time he made the declaration. Now, I'm an experienced lawyer, and I am afraid, my fear is that Mr. Lowenfield is going to come and claim that he received Mr. Mingo's declaration and sent off that letter before he was served with the order. Let us wait and see.
Mr. Jones, speaking of Mr. Lowenfield, attorneys Mendes and Mangal have asked that he be present for these hearings.
Mr. Mingo and Mr. Lowenfield, they are required under the rules of court to be present. They have been noticeably absent. Our attempts to serve Mr. Mingo personally with our own objection, and the United Guyana objected. We had until midday the following day to serve him. We were not able to find him. We had to serve it, and we were successful. We were able to serve it before 12 o'clock at the GECOM head office. We received the acknowledgement of that service. We went to serve it at the Region 4 office, Ashman's building. We were prevented by police from accessing that building. We have since received no response whatsoever from GECOM. Now, I anticipate that GECOM will respond and say something's wrong with your service, or the person who signed your objection is the wrong person to sign, or maybe it's on the wrong color paper. I suspect GECOM will respond to say something like that, but there hasn't even been the decency of a response. We know that insofar as the PPP's objection was concerned, GECOM said the wrong person signed. We know that insofar as LJP's objection was concerned, GECOM gave some other ridiculous excuse. I'm waiting to see the ridiculous excuse they give us, but I can tell the media that we did serve it at GECOM's head office before 12 o'clock the following day, and there has not been the dignity of a response as we speak.
Do you think there's a role for CARICOM as a mediator in this
the lawyers are leaving the chambers.
The CARICOM chair, Prime Minister's practice in advocacy, and asked that they continue the same platforms with Mr. Judicial and Mr. Campbell.
Later. Yeah, all right.
Give me some space, please.
United has observed the process by which APNU have informed the nation that they have won the election. Senior representatives, including Mr. Greenfield, have spoken to the nation to say that
So
they
we
are
can
proceeding
segue out,
with
Devin,
as soon
and
as
we
they
can
get
move on with our
this small hurdle out of
So viewers out there, there you have it. That has been interviews with various personnel at the location of the High Court in Georgetown, Guyana. You have seen interviews with Mr. Boston, with Mr. Anil Nandalal, with Mr. Schumann, and current ongoing interviews with our good friend Mr. Timothy Jonas. Just to remind everyone, we are expected to be joined with some panel members just now, expecting to have a little bit of a legal discussion here tonight to discuss the implications of these. Mr. Derek Arjun, you have just joined us. Good day to you, sir.
Good day, good day.
How are you today?
Quite well, thank you.
All right.
How are you?
Very well, thanks. Well, I don't know if you would have heard the news that the Madam Chief Justice would have given her decision.
I did.
And what's your initial thoughts, sir?
Actually, I was looking at her issuing her decision. Well, listening to the audio, she issued the decision.
Okay. Okay. Is there any comment you wish to make in terms of give your legal experience, forget which side of the political state of play you might want to support, but you've had years of looking at things from a legal, with your legal spectacles, your legal lens. What's your thought process in terms of the legal paradigms here?
Well, I am not surprised that the Chief Justice found that there is jurisdiction in the court. When you look at 163(1), it clearly says, actually it's A on the E Roman I, it says that the court has exclusive jurisdiction with regard to any elections, and it goes on to say either generally or in a particular place. So if you were to read 163, you will see that the court does in fact have jurisdiction. But it seems as if that the entertaining of jurisdiction by the Chief Justice is being interpreted that there has indeed been a violation of the election laws, and that is not so. There is a, based on what was presented to her, a problem with elections in Guyana. That those elections occurred on March 2nd. And she, looking at those papers, found that there was a prima facie showing, a initial showing that something occurred that justified the invocation of the court's jurisdiction. Okay. The next question is, what is the extent of that jurisdiction? She looks at it, but what is the extent of her jurisdiction here? Does she, as Mendez seems to be urging in a very seductive fashion, intervene to progress this election to a fair result? Is that what she does? Does she have the right to intervene to progress the election to this fair result? And this is where we have to be careful. The intervention that Mendez is urging on behalf of his clients is dangerous because you could have these interventions by the PPP and other parties, and we could be in an interminable situation to the extent that we don't meet the 15-day limit.
Right. So, Mr. Arjun,
required for a declaration.
Right. Before we go to discuss, before we go to discuss the 15-day limit, which is another question I have for you, let me welcome Mr. Larry Lala, who is a senior attorney in Trinidad and Tobago, who is also very familiar with CCJ and with Guyana events and court cases across the Caribbean. How are you, sir? Welcome to our platform.
Hi, good afternoon, everyone. Thank you very, very much. I'm very happy to get involved in the discussion.
Thank you. So let me say it this way, Mr. Arjun, you made an excellent point that while the Chief Justice would have determined that the court has jurisdiction for a judicial review, the word she used was judicial review in the process. Your notion of, well, how far does this extend, and whether that extends to what you are saying, tell me if I'm wrong, that it can lead to a fair result, which she should have nothing to do with the result. She's constrained, or the court at this time will be constrained to the process, right or wrong?
Correct. Correct.
Okay.
Her concern is the process. Her concern is making sure that she's a court and the parties respect the independence of GECOM. And just to be clear, if she were to get involved in looking, more properly intervening in the process as she's being urged, she might very well be stepping on the toes of GECOM. And I want to go a little further. I was listening to Mr. Jonas after the case had ended, and he was talking about having served papers or attempting to serve papers on Mr. Mingo and Mr. Lowenfield. I wasn't sure what those papers were. But if I may, for the sake of argument, say that those papers might have been injunctions they're seeking with regard to other aspects of this election, with media Region 2, Region 3, not Region 4, but other aspects, then this situation is exactly what I believe the framers anticipated when they said that this kind of controversy should be properly looked at through an elections petition.
But Mr. Arjun, sorry to interject, wouldn't that then be in hindsight, which is the court has vacillated, or the Madam Chief Justice has paid keen attention to the case of 20 years ago when Madam Bernard, Chief Justice then, said, well, you should not wait to suffer the consequences and then cry about it. Basically, those are my words. I want to bring on Mr. Lala here. Sir, before I ask you your opinion of the general process, what you would have heard in Guyana, there's something that Mr. Arjun also mentioned that is of extreme importance to the process here. Does the court's intervention, for the lack of a better word, in this process affect the constitutional 15-day limit for a declaration of Guyana's election results?
I can't say. I mean, I haven't seen that actual provision. But it is apparent to everyone that the Chief Justice has in mind that she has to move very quickly with this matter.
Correct.
She's making every effort, from what I heard today, to make sure that all the evidence that the parties would like her to consider would be before her on Tuesday. And she has indicated that, again, they should be prepared to work long hours on Tuesday. So it appears that she has very much in front of her the importance of getting this matter that's before her done in an expeditious manner.
Yeah, and she did. She basically admonished the attorneys present today that the nation is awaiting us all, and you guys want to have an
Absolutely.
extension
Yeah, I
of
mean,
time. So
yeah, I mean, I would imagine though. I mean,
yes,
I would
go on.
imagine that it's a very laborious process as well for the attorneys. I mean, it can't be easy for them to be operating under this pressure. But I mean, they sound. I know Dr. Mendez from Trinidad, extremely competent senior counsel, and Mr. Boston sounds as though he's on top of things at his end. So one would expect that on Tuesday, once the hearing starts at 2 p.m., I mean, they're going to be running to the finish line.
Yes. So, to our viewers out there, those of you would have been introduced to Mr. Arjun 2 nights ago when we had our first discussion. But Mr. Lala, who is London House of Chambers liaison counsel to Trinidadian clients doing business in Guyana. He has had years of first-class experience in the Trinidadian legal system, and of course, by saying that is the Caribbean legal system. Gentlemen, correct me if I'm wrong. But he is highly respected. Mr. Lala is highly respected across the Caribbean. In terms of both legislative matters and business matters, and the span of expertise upon which he casts his legal lenses is quite wide. Goes from trade and commerce to, of course, constitution and appellate practice and education. He's also had bar admissions at the Florida Bar, the New York State Bar, and of course the Trinidad and Tobago Bar. Sir, I have Mr.
As well as Guyana.
And thank you so much. I was going to ask you what's happened to Guyana in the process. Mr. Lala, if you don't mind me asking you this, sir, while you may not have been as enjoined in the process as some may prefer you to be, what's your general feel, using your legal cap, what's your general feel for what has happened thus far in the Guyana elections, especially in the declaration of results?
Well, it appears to be very simple, and listening and looking on at all the comments made by all the international observers, everyone who has ventured to say something on what has happened so far, it appears to be a very simple issue. That is, there's a process which has been set out in Section 84 that should have been followed, and it has not been followed. And therefore, they want to get the election back on track and have the proper process followed. It appears to be a very simple issue. And for some reason, the whole thing has been derailed. I just want to go back to what my colleague was saying a short while ago in relation to the election petition. It was clear from what the Chief Justice said that she has very much at the front of her mind that there are some issues that could only be dealt with by an election petition, and therefore she's going to exercise great caution in deciding what issues she treats with in this process, so that she does not go beyond the jurisdiction that she has found that she has to deal with the matter before her.
Well said, sir. And again, that's an important point to remind our viewers. Look, the Chief Justice today, and let me say hats off to her. I mean, on behalf of the GlobeSpan team, on my personal behalf, I wish to say hats off to Madam Chief Justice. She has once again stood out across.
I feel very, I felt very proud this afternoon for a number of reasons. One, the way the Chief Justice presented her decision, I think it was very clear to all. But I have to congratulate you guys, because I mean, I can sit in my home here in Trinidad and hear very clearly the decision which was given by the court in Guyana. And I think you guys have to be congratulated for the effort that you have made. People are listening in on what you do from all over the world. I mean, I was looking on at the comments that were being made. There are people all over the Caribbean, people in New York, people in the UK. They are all listening, and they have all been facilitated because of your efforts. And I think you must be commended for what you have done today.
Thank you, sir. And let me bring both of your attention to something both of you mentioned. You mentioned it more recently, sir, Mr. Lala. That is, to our viewers out there, look, it is extremely important that we understand a couple of things. The Chief Justice has not made a declaration on anything other than whether she has the jurisdiction. In other words, whether she could hear the petitions of the PPPC and the other parties who would have taken their matters to court. So in other words, she has agreed that she can listen to them. Yes, sir?
No, go ahead. I'm listening.
No. Do you agree with that assessment, with that summary?
Yes, absolutely. And she was a great pains to explain that.
Great.
Because of the importance of the issue.
Correct. And to Mr. Arjun, I want to come back to you because timing is extremely important. Now, from the inception of her of the pleadings yesterday in front of her, she said, and she has consistently repeated over and over, time is important. I am working, and my court will work all weekend if we have to make this happen. And in closing, she said, be prepared for a long day on Tuesday. In other words, she has shown even more character by saying, look, the courts are going to do whatever it has to do to ensure that there is no delay. Mr. Arjun, your thoughts?
Well, that's highly commendable that she recognizes the exigency of this situation, and she is prepared to do all she can and also use her court personnel and also ask the lawyers to work with her to ensure that there is a fair and just result to what is before her. She showed maturity and confidence from the time she started yesterday, and this is consistent with the way she's behaved in previous cases.
Yeah.
But even though her promise and behavior are quite pleasing, we still have to recognize that we have this 15-day limit, and we can't at any time allow the urgency of the case to interfere with a result that is ultimately just. And you know, when we're rushing like this, despite you might have the best minds and applied, there's still that danger that we might not do our best in the circumstances, and let's hope that we do. But again, I refer you to the intention of the framers. You might bemoan the gaps in our Constitution, but when you look at the document overall, it is a fairly sound document written by men and women who thought long and hard and judiciously about what should be in that Constitution.
Right.
And I am moved to say that what we are witnessing today was envisioned by the framers. And in a bid to make sure that we didn't have the kind of confusion that is going on, they inserted the Judicial Petitions Avenue to look at these things, and also said that the court can look at matters relating to an election, but there's nothing in there, nothing in the Constitution that specifically empowers the High Court to reach in to the process and interfere with what is going on. And I believe that the Chief Justice will be so guided when she makes her decision on Tuesday.
Okay, understood. Yes,
I think though, I mean, I don't know what is the thinking going on in the GECOM's camp, but One can't at this stage rule out the possibility of an appeal being lodged with the Court of Appeal on today's ruling on jurisdiction. And if that happens, well, it's anyone's guess what goes on after that.
Yes.
Yeah, that is always possible, but I don't think GECOM will do that.
So, Mr. Lala, let me ask you this. I mean, just hypothetically, if from your experience, I mean, if there is an appeal to Madam Chief Justice's decision, would the appellant, would GECOM then have the wherewithal to proceed with the declaration and swearing in, or it would still have to wait until the appeal is finished?
Yeah, I mean, I think the courts would be act in a responsible manner and would leave the injunction in place, until there is a proper hearing. If it goes to the Court of Appeal, they would leave it in place until they hear that appeal. I don't see anyone lifting that injunction in the meantime.
Okay.
And if I may, Yoke, I recognize that possibility exists, but I don't see it playing out. There's a country to run. There is security to be provided. There's education to be provided. There are roads to be built. There is a Guyana that exists at this moment. It's a country of nearly 1 million people. And we have to have a government of the day. And that government of the day cannot be held, its functions cannot be held in abeyance because everything sits in the court. The government is the primary guardians of the people. And while the courts are a part of that arrangement of protecting the people, it is the government's primary responsibility. And so we need to have some finality to this process as quickly as possible.
Correct. So let's hope that it can proceed quickly. Mr. Lala, one of our viewers has sent a question to me for you. I'm afraid we will plummet you into a little bit of a political realm. Please feel free to not answer. But all around the world, this viewer is saying that even France, all over, people have made a comment, but the Trinidad and Tobago Prime Minister has said that they don't want to get involved in Guyana's affairs. Any comments, sir?
Right. Yeah, well, I mean, I saw even St. Kitts, I think it's in Lucia, made a comment. I mean, one would hope, that regionally leaders would see the importance of this issue and they would see the need to make a comment. And no one is saying, no one is getting into who has won or who has lost. That is not the issue. The issue is the election process. And, one would have hoped that we would have gotten a comment from, but we have an acting prime minister because the prime minister at the moment is in Ghana. But one would have hoped that the acting prime minister would have seen the wisdom in at least lending Trinidad's voice and support for the process in Guyana. And because I think it's very important that as a region, we are seen to be persons who believe in democracy and believe in free and fair elections being conducted all throughout the region. So I think that Trinidad missed an opportunity to lend leadership on this issue.
Yeah, I think also a lot of people feel that Trinidad and Guyana really ought to have been much closer than they are. There seems to be a real, normally there is a love-hate relationship, but this one seems to be a hate-love kind of relationship. And we wish, we wish it could have been better. But thank you for that, because it really puts us in a strong stead. Because yes, there'd be times when Trinidad would certainly need us. In the past,
absolutely.
In the past things might have been different. Mr. Lala, I want to come back to you on another point. With regards to the process, because I want to ensure we remind readers that, look, the Chief Justice will constrain herself and just give me a moment here, let me explain this. So the Chief Justice is not going to, or the courts are not going to intervene in the process for the declaration of results. Let's get that straight. She is going to look, or she will allow the attorneys to bring her attention to specific processes that they feel have not been followed. And if she, if in her legal judgment she feels the process have been breached, she will say so. Yes, sir.
Yeah, I mean, that appears to be where she's going. Of course, we have to be careful. The matter is sub judice, so we don't want to give too many opinions on what should be done and what shouldn't be done. But it appears, when you listen to the Chief Justice speak, she is very measured in what she says. She chooses her words very carefully, and it appears that she has very clear in her mind what she could get involved in and what she can't get involved in, because this is not an election petition.
Okay, thank you. Mr. Arjun, a question from one of the viewers. Do you think that Mr. Mingo has acted within the law or the legal guidance per law for 84.1 for GECOM?
Well, one has to be mindful of the factual controversies here. And I have stated before that I understand that Mr. Mingo's responsibilities were seriously impaired by the ruckus and disruption that occurred while he was doing his assigned duties. That is my understanding of the facts. Maybe the viewer has a different understanding.
But let me interject there.
Sorry.
So let me interject there, because that exact question is what we asked of Mr. Timothy Jonas before. That is, did you guys interfere with Mr. Mingo's right to do what he has to do? And I've asked this of Anil Nandlal, I've asked of Sanjeev Dattadin, I've asked of many persons who are present on this show, I've asked them. And they've all agreed to one thing. Mingo's job of verifying the polls was never hampered or interfered with. It is only when Mingo appeared that he wanted to give a declaration after having subverted the process that they said no, no, no. So the veracity of the statements coming out from all the different sides, of course, we have to check it. But the contention seems to be that Mingo was not prohibited from doing his job in terms of the verification and going with the sections of the Representation of People Act.
And I'm happy that you used the word contention, because it is a contention that he was not. And from my sources, their contention is that he is. And this brings me to a further point with regard to what the Chief Justice has in front of her. The lawyers for the two sides will be arguing about what occurred. And Mr. Lal rightly talked about the Chief Justice paying attention to what occurred. And you're going to have a mini trial, if you will, to the extent that one side will be saying this and one side will be saying that. The question is, does Tuesday present a proper opportunity for the airing of factual disputes as to what occurred when Mingo was counting? Does it?
But Mr. Ayers,
this is why I'm saying that the particular legal mechanism used here would not be sufficient to ferret out the truth. You really need an elections petition.
But sir, again, I mean, I would take you back to the court case. I would take you back to that case that seemed to have been the pivot upon which we would have had the Hamilton versus AG of Guyana. In Hamilton versus AG, for viewers out there, what had happened is that the attorneys, Mr. Boston, Basil Williams, et al., they then appeared 20 years ago in front of the court, asking the court to allow them or to have the court brought into the process. They petitioned the court to intervene, or intervene is just my word, it's not legal, but to step into the process to ensure that the process was being followed. The court opined that, look, it would not be good to allow the country to suffer the consequences and thereafter have an elections petitions. If you can correct something in process, then do it. Mr. Lala, I would want your legal thinking on this, sir, because it is, I'm not so sure if you would have had a chance to look at Hamilton case, but it is an important case in the history of Guyana. And strangely, for viewers out there, 20 years ago, the people who are now the defendants, the attorneys, were then the plaintiffs. Things have really turned 360 degrees.
I heard Mr. Jonas saying. Yeah, I mean, so the parties have gone before the court on a fixed date claim form, and they have affidavits. If there are areas of dispute, and one might expect there to be, the court would have the power to allow cross-examination on limited areas. So yes, I agree with Mr. Arjun that there could very well be a mini trial, but I don't think we should underestimate the ability of the court to deal with that issue if it arises. And the court could allow cross-examination on limited areas as far as the evidence is concerned, if the need arises.
Thank you. And yes, I'm mindful of what you said earlier, Mr. Lala, that Chief Justice, in reading her decision out, well, in listening to the pleadings, there were times that she admonished the pleading attorneys, you are crossing the line. I don't want to hear anything to do that would cross the line of becoming an elections petition.
Yeah.
Mr. Arjun, you are convinced that this process should not have been allowed. It appears to me, sorry, I'm not putting words in your. It appears to me that you're convinced that, or you feel that this thing should just have been dealt with as an elections petition.
Well, I think it should have been properly dealt with as an elections petition. I do not have a fundamental opposition to the Chief Justice's decision today that the High Court does have jurisdiction, or having with regard to 163. I could see where she might feel that the High Court does, despite my preference for this thing proceeding as a judicial petition. As an election petition, given all the pitfalls that we are faced with as we move from yesterday's argument to today, and then all of the proceedings to follow up through Tuesday. So yes, I believe it should have been better, and I could guarantee you that come Tuesday, despite the impartiality, the legal understanding of the Chief Justice, and her diligence, you will hear, if a decision is not handed down that is favorable to the petitioners, that are the ones who are seeking to stop this whole process, that she did not do what she was supposed to do. She fell short of a constitutional. I could hear that, and I believe that the perils of this process, of these few days and handing in affidavits and doing arguments, lend to that kind of conclusion, unfortunately. And it might more darken the waters than enlighten her. I do wish her well. She is a sterling public servant. She has done well in Guyana, but I think this might be a tall order for her to carry out in the circumstances. The whole of Guyana waits, and the Guyanese population and the rest of the world does, and then the rest of the world is also looking on. A very, very difficult task at this time.
Mr. Lala,
I would disagree a bit. I mean, everything that I've heard so far, and I've seen in the Chief Justice's conduct of this matter, I mean, I would have confidence in her and her ability to deal with this properly and obtain a result which any reasonable, fair-minded person listening in could feel confident in.
Mm-hmm. Correct. And Mr. Arjun, I mean, one of the viewers asked me to rebut you with the following: Would your position be the same that you would have feel vindicated if the decision had gone the other way?
Meaning what? If she had said there was no
that she
jurisdiction?
cannot. Yes, that there.
Oh
yeah.
no. As I said, I could live with that.
Okay.
I could live with that.
So I want to bring us to another crucial point in the court today. A little bit of drama towards the end, when Mr. Mendez, as you rightly pointed out, you mentioned it, Mr. Arjun. Mr. Mendez sought the court's attention to the fact that, notwithstanding the injunctions being in place, Mr. Lala, notwithstanding the injunctions being in place, the chief elections officer had proceeded to do such acts as might be in contempt. That's my word. This wasn't used. The words weren't used in court.
No, because indeed, Mendez pointed out that in addition to asking Mr. Mingo and Lowenfield to be there possibly, that it doesn't exclude seeking contempt down the road.
But shouldn't they be there, Mr. Arjun? Aren't they required to be there?
No, I mean, you know, they're representing organizations. Mingo and sorry, Mr. Lyle, Mingo and Lowenfield work for GECOM.
Well, they have been missing.
There's ordinary citizens working for GECOM.
I asked a lawyer last night that given that Mr. Lowenfield is CEO, given that he, in the eyes of the public, who, you know, I mean, we have hired him basically. We are paying him. He left his job a day after the elections and has not been seen since.
Well,
I mean, I agree with Mr. Arjun. I don't think there was a need for Mr. Lowenfield and Mr. Mingo to be there, but certainly a representative of GECOM who could transmit to all GECOM servants and or agents, which is what Mr. Mendez mentioned, that they are bound by the injunction which has been granted. So no one should be doing anything that moves in any way whatsoever towards a result. Everything has to be frozen in time. And if this document was issued by Mr. Lowenfield, then it should not be done. You know,
so one of the viewers, Mr. Lal, sorry to interject. A matter of technicality maybe, but your opinion is needed. So one of the viewers have pointed out that they may have been required to be there for the case management part, which was the last part of today's proceedings.
Well, someone who represents GECOM, right? And the action, to my knowledge, doesn't specifically mention Mr. Mingo and Mr. Lowenfield. So in that instance, they were not required to be there specifically. But the ambit of the injunction which has been granted would cover them because they would be the servants or agents of GECOM. You know, so you can't argue that the injunction covers GECOM, but it doesn't cover the CEO of GECOM. You know, it covers everyone.
Right.
who is conducting the work of GECOM.
Right.
So they are bound by it, and they should be doing nothing towards moving towards a result while the matter is before the court and while that injunction is in place.
Mr. Arton, what's your comment on that?
Oh, absolutely. It is well said. They are servants of a public institution, and they're obligated to follow whatever orders are issued against that public institution, and in this case, it's GECOM. So whether the injunction says GECOM and or its agents, servants, are barred or prohibited from doing certain acts, that language encompasses fully Mingo, Lowenfield, and any other relevant official that works within GECOM.
Okay. Yeah, I mean, it's neither here nor there in terms of what's happening there now. The good thing is the process is underway and with alacrity. But I think the injunction did mention them by name and then said, and any other servants or agents and so forth and so on.
Okay.
So it did mention them by name. But the other thing that we are mindful of as a public now, as an onlooking public that is very interested in the process, is that notwithstanding the injunction being in place, Mr. Lowenfield issued an email that was released to the public calling for a meeting of the commissioners to hand in his report. The good thing, though, viewers, is that at the end, the court asserted, and Mr. Boston, who represents GECOM, Mr. Boston gave an undertaking to the court that the court's wishes and the injunctions and everything will be upheld, adhered to strictly. Your comments, Mr. Lal?
Yeah, I mean, that he did the proper thing to give the undertaking, and one would hope that he would have gone back to GECOM and explained to them the importance of that undertaking. He haven't given that undertaking to the court. I mean, one would hope that no one would do anything to depart from the terms of that injunction. Because, we have to respect the court. The whole society falls apart if it hasn't fallen apart already. The whole society falls apart the day we stop paying attention to court orders.
Correct.
And it's important that Mr. Mendez reserved his position in relation to contempt of court, which is, a very serious power that the court has to deal with persons who choose to infringe upon its orders.
Indeed. And also, Madam Chief Justice, I think, was very plain in her words in commencing today's proceedings to hand her decision down. She started by admonishing both sides that you have to be respectful to the courts.
Yeah, absolutely.
So go on.
Well, no, I was just going to say it's one of the key branches of government, one of the three branches, and its functions are essential to the stability and good order of the society. And despite the problems Guyana has had, we have been, by and large, an orderly society, and much of that has to do with the independence and competence of our judicial system. We could do better, but nonetheless it has functioned so it's to a certain degree of satisfaction. So we certainly don't want public officials to start flouting the orders of the courts.
Right.
That is the beginning of anarchy.
Correct. Yeah, and the other thing I would like to quickly take you back to is, let's divide this thing up properly. Look, the elections have been declared as perfectly run. The elections have all been declared as well run. Everybody has given it their certification of approval, in their own way. The election day, that is. Sorry, the election is not finished as yet, but sorry, election day proceedings have been given a well thing. But what started to happen is it descended into chaos thereafter, because here is what happened. And Mr. Arjuna, I would welcome your comment here in terms of the documents I believe Mr. Jonas was referring to that they were unable to serve, included in part, but in main part, their request for a recount. Now, as you would recall, Mr. Lala, I don't know if you know this, but as you would recall, Mr. Arjun, the CEO and the RO for Region 4 disappeared. The Martians probably took them, but they disappeared. And so 24, you had 24, or well, the opposing parties, the contesting parties had 24 hours after that declaration upon which they could file their request for a recount. They were not allowed, at that time, it was deemed that they were not allowed to file that recount because nobody was there. The good news is that, I mean, it's discussing something that probably is frivolous, because the good news is that thereafter, I believe that they were allowed to at least present that the paper. Whether the recount itself has been allowed is now, you know, outside of our discussion, I guess, because we have gone back to examining the process. Now, here is a question for you and Mr. Lala. Examining, if the court is now going to examine the process, does it hold in abeyance, or does it, for the lack of better phrase here, does it throw away the declaration made by Mingo?
Well, I think there is some uncertainty as to the legal validity of that declaration. I mentioned to the Chief Justice, I think in court there was some uncertainty as to the legal validity.
Okay. Because I think the lawyers were called back in chambers. I'm hoping it would have been for some discussions like this.
Yeah. Well, if I may,
sure.
I don't know what our thinking is with regard to that. Again, we have to go back to the factual underpinnings of that declaration. You are saying that you understand Mr. Mingo did not complete the process. My understanding is that he was doing it and he was interrupted. And he could have gone to the back, he could have gone in another room and completed it. And so from a legal standpoint, one could argue that he was doing what he was obligated to do. And because of the dangers that he was presented with, he had to complete the process in a different room, but he did.
Right.
That is a factual determination that the Chief Justice would have to make. Of course, I maintain you've heard differently. I have heard differently. I think your sources are sane, and my sources are sane.
No, but I think we're talking about two different things. I am referring to the process before he declared. In other words, the verification itself, which is 84.1, the ascertaining of those SOPs.
And I'm referring to that.
Completed.
I'm referring to that.
Okay.
That he was indeed doing that. And as I understand it, underline that, the controversy started with the use of a spreadsheet, a tradition that obtained in other regions and that is obtained in other elections. Once that was used, there were arguments and there was pushing and there was shoving and all kinds of unhealthy behavior. Now that is my understanding, and I'm told that threats were issued. Now, of course, the persons who are seeking relief are saying we didn't do anything. We behaved like angels. We were well behaved. In fact, I just looked at Jonas, and I'm not saying that he's not a good human being, but he was telling the journalist, "I'm not answering the question. I don't believe I should. I don't know why. Why don't you answer a journalist's question, even if you have had a problem with him in the past? You have an obligation as a public official here, as a political figure, to answer a question of a journalist." But he said he wasn't going to.
No, I think I think he had a problem with he expressed that he would not respect any questions coming from a particular journalist. When the same
particular
question,
person, I saw
You see, that is the immaturity of our politics.
Gentlemen, let me interject and let me welcome Mr. Ralph Ramkuran. Senior, how are you?
Good, fine, thank you.
What's your knee-jerk reaction? Give us what's your feeling at this moment, given that Madam Chief Justice had handed her decision down?
Well, I'm very happy with the decision. I think the decision was in accordance with the legal position as we understand it, and that it is the major obstacle to a positive ruling eventually. I think this point was more difficult than the next argument. This argument was related to the jurisdiction of the court. And while there have been two decisions in Guyana, which supported the point, which supported the argument of the PPP, that prior to the decision, prior to the announcement of the results of the elections, that the court has the power and the jurisdiction to intervene to ensure that the rules and the laws are obeyed in the process of the elections. There are two decisions in Guyana supporting that position. Still, it was not a cut and dried case. And therefore, I think this is the major aspect of the case which has now been decided. The second aspect is as to whether the returning officer complied with Section 84. Now, it is clear, the world knows he didn't comply with Section 84. He didn't count the ballots. He didn't arrive at a decision having reviewed the ballot, the statements of poll. And therefore, that is not a difficult position for the Chief Justice to discern and to pronounce upon.
Yeah. Well, thank you for that. Very succinctly put, sir. Here is another finer point that we were wondering about. Now, does the court look? Admittedly, CJ has said she's mindful of the timing, and she admonished the attorneys who requested a lengthy time that the nation is waiting. But we are mindful of the 15 days deadline of the procedure 2 of the section of the Act. Does the court's intervention in the process affect that 15 days declaration?
Well, I think that the matter will be finished in 15 days. From what the Chief Justice said, they will have to sit. They will have to sit late on Tuesday. I think that it is not a big issue. There are no legal authorities to anymore to go over and to decide upon. It's really a question of fact now. So that should not take up too much time. It should finish on Tuesday. And from what we have seen the Chief Justice to be doing, she should have a decision the following day or within 2 days. So the time will, I'm not worried that they'll exceed the time. But even if they do, unlikely, but even if they do, extra time can be given. An extension of time can be given, assuming that let us assume that the Chief Justice rules against, she has to rule against one party or the other, but let us assume that she rules against the government, against the Mr. Boston's clients, that is the returning officer, the Chief Election Officer, and the Elections Commission, and they take the matter to the Guyana Court of Appeal, and then to the CCJ. The 15 days obviously will elapse, but then the court has power to extend that time.
Oh, well, great. Sir, another finer point of our discussion that we would have been deliberating on, and to our viewers out there, this is Mr. Ralph Ramkuran. He is former Speaker of the National Assembly and also a lawyer, at least all my life. Not meaning that he's an old man. He's quite a sprightly young man. But his advice and opinion in the Guyana legal scene has been well respected. Mr. Ramkaran, in terms of the deliberations or the considerations of Madam Chief Justice, she today, that little last minute drama that came out on basically a question of contempt. As you know, Lowenfield sent out an email. What was your state of mind when you saw that the email was sent out by Lowenfield, notwithstanding the injunctions in place?
Well, I immediately felt that the Elections Commission, that Lowenfield was asking the Elections Commission to violate the injunction by inviting the Election Commission to convene a meeting and pronounce upon his declaration, pronounce upon his report. The Election Commission did not take the bait, but the fact that he compiled a report was in itself a violation of the injunction, because the injunction required him not to prepare a report. Mm-hmm. But at the end of the day, the Chief Justice got an undertaking from Mr. Boston.
Correct.
Mr. Lowenfield will not proceed to violate the order which has been made by the court. And I think that was sufficient to ensure that nothing further happens either by the Elections Commission or by Mr. Lowenfield.
Okay. So
certainly the lawyers accepted it.
All right. So, Senior, one last question for you here. What, as of this moment, what is the status of Mingo's declaration?
Well, it's stayed. Mingo's declaration is stayed. He can't do anything with that declaration. There's nothing further that can proceed out of that declaration. The order sought by Mr. Nandlal and his client is that no declaration is made by the chief election officer until the votes are counted in pursuance of Section 84(1) and 2 of the Representation of the People Act on a lawful declaration made by the returning officer. So he has to forget that, quash that declaration, just discard it. Eventually, if they succeed, he would have to discard that declaration and start over.
They would ask for it to be declared null and void, non-existent in law.
Well, I don't know if it will be specifically declared null and void, but if the Chief Justice rules that he must comply with Section 84(1) and then issue a declaration, it would impliedly mean that will become null and void.
Mm-hmm.
Yeah, correct.
Well, I would wish to, I'm not so sure that either of the three of you would know this, that notwithstanding the injunctions in place, and not, for one moment, if we put aside even the email that Lowenfield would have sent out, the GECOM website would have been updated at around a little after 12. That is this morning. So people were there obviously working, and they would have updated their website with all 10 regions. Doesn't that make the CEO then to be really in contempt, because that's a public declaration?
Well, the CEO is clearly in contempt of court, but sometimes they don't. I think the parties accept it, and Mr. Mendez and Nandlal appear to accept Boston's undertaking that the CEO will not violate the order. So sometimes you don't, insist on every fine detail that is necessary in court. They got that from Boston, and they seem to think that is sufficient for them.
Great, thank you. Well, Senior, thank you so much for joining us with your August Council. We always look forward to your being with us on the show. And we also have Mr. Arjun from New York, and we have Mr. Lala from Trinidad and Tobago. Senior, we asked Mr. Lala from Trinidad and Tobago why Trinidad is the only country in the world that didn't make a statement on Guyana.
Well, some Barbados made a statement. Well, you can understand Barbados. The Prime Minister is the head of CARICOM,
right?
The current chairman of CARICOM. But St. Vincent and the Grenadines made a statement. That was important. But you know, we always had our suspicions about CARICOM and Guyana. So we look. I mean, even the CCJ case, which I heavily criticized because of their failure to say that elections should be held by September the 18th.
It was actually.
Sorry?
Mr. Ankran, go ahead. Sorry. You go ahead.
No,
I'll come in
so
after.
I was saying that the CCJ failed to say that the election should be held by September the 18th, which enabled the government to postpone the elections right down until March. So we just have to live with CARICOM, whatever we get. We got St. Vincent and we got Barbados. That's a lot.
Yeah, not every country said something. Look, they're still our brothers and sisters. We expect them to stand with us when it's necessary. We often mount this principle of non-interference in the affairs of other states, and we expect that our brother and sister states in the Caribbean to run and pronounce on our affairs. I don't think that's necessarily so. I believe that what Trinidad did is correct. I still believe that Trinidad considers Guyana to be a sister country, and so does the rest of the CARICOM. So these things, we have to pay attention to principles that we stand upon to. I everything that happens in our countries.
I think if all of these voices, which did not, if they did not come out, so if we did not have the American ambassador in Guyana, if we did not have the EU, if we did not have Norway, if we did not have the OAS speaking out, we may have been in a very different place today. So I think it's very important that all of these voices came out in unison and condemned what was happening. I think CARICOM in its first statement was very, very weak, and then pressure started to come down on CARICOM to say something further. And it was only then that Mrs. Motley came out with a second statement. So I think CARICOM was lacking. They did not provide leadership in the circumstances, but thankfully there were other very loud voices saying quite clearly that this election is running off course and we need to do something.
Yeah, thank you.
Quite apart from that, issues of human rights, violations and so on, go far beyond intervening in internal affairs of other countries. I mean, the UK, the US, the European Union, they all made statements. I mean, they could be considered to be intervening too.
Yeah.
So anyway, but CARICOM has a
we
with
can
Guyana.
continue
The
on that.
CARICOM leaders do not interfere, do not say anything about Guyana. That's a historical. They allowed Burnham to sit down in power as a dictator for 28 years. Said not a word, not a single word.
Let's stay away from that because there were other events that they should have pronounced upon. So let's talk about Burnham only.
Senior, I would want to ask you a question that you might want to say is based on hypothetical scenarios. But here is the question, and Mr. Lal, Mr. Arjun, you can also comment thereafter. Here is the premise to the question first. A little while back, it was the same Madam Chief Justice that gave her opinion that Granger should not have or could not go and have his arbitrary appointment of a chairman. That was ignored. it was the same Madam Chief Justice that took a decision that the NCM was validly, that no confidence motion was validly passed. The government took the matter to the appeals court, and then it went to the CCJ. The CCJ said elections must be held or should be held within a time, and the government did not. They just blatantly refused to, and elections were supposed to be held in September. They are now held in March of the next year. What confidence do Guyanese public have that the decisions of any court with regards to GECOM and or this government will be followed by the government, given their dispensation to just ignore court orders?
Well, I don't. The government didn't say that. The government said that the CCJ did not rule the date by which elections should be held. And while that was not fully accurate, there is no. The CCJ said everybody knows the date by which elections should be held. So the government seizes on every opportunity and every loophole to have its way. Hopefully, this case will not be one like that. Hopefully, the court will make a clear decision that the returning officer violated Section 84, and that he must resume the count on the statements of poll.
Okay. Mr. Arjun?
Well, I think you're asking the panel here what is their opinion. The question is, what confidence does the Guyanese public? I don't know if all of us or they in particular represent the Guyanese public. Yes, elections might not have been held as some people wanted, but the CCJ said that give some kind of guidelines, and importantly said that the political actors must know what they're doing. So there was no prescribed date for an election. Besides, I believe that this government has been largely observant of the law and the Constitution. I need not go into facts and details, despite what the senior counsel talked about Burnham being a dictator. But I believe the Granger administration has been largely a law-abiding organization, and I have the fullest confidence that whatever the Chief Justice decides on Tuesday or Wednesday will be indeed followed and upheld by the government.
Okay.
Well,
thank you.
I certainly hope so. That's not our experience, but I hope so.
Mr. Lalo, what's your thoughts on that hypothetical question?
No, I mean, we would have to wait and see. I mean, I agree with you that, and I agree with Mr. Ramkaran that it appears as though wherever they could find a loophole and they try to run through there, but we'll have to wait and see what happens.
Okay, so Senior, I have a question for you that does not relate to today's happenings. Just your opinion. Every time this discussion comes up about the current election fiasco and swearing in and all of that, you know, there are many elements of members of the public, and elements of the pro-government elements would always throw up the paradigm of the Janet Jagan era, and that my response has been, by and large, look, even the Constitution was different then. It's a different paradigm. But, you know, I've gotten the question here to ask you whether the CARICOM and what's your situation on the swearing in of Janet Jagan at the 2015 elections, and whether we should not now just accept what's going on and leave it be.
Well, the Janet Jagan swearing in was not unlawful. It was a lawful swearing in. The only problem with the swearing in is that it was not recorded on film, but it was the document. The document was a lawful document. It was presided over by just the Chancellor, Justice Kennard, and the declaration was made by the Elections Commission prior to the swearing in. There's nothing to say that the swearing in must be public. So, you know, it's the same rules. If the Constitution hasn't changed, it's the same principle by which the swearing in is to take place now. So the swearing in can be, you know, it has to follow a declaration by the Elections Commission or approval of the Elections Commission of the declaration by the Chief Election Officer.
Okay.
That's all that's required.
Right. So basically this entire current scenario would have revolved, well, not revolved, would have come out of one point only. That is that the ascertainment or the verification process of the SOP failed. Senior?
That's the only issue. That's the only issue.
It appears so, yes.
Yeah.
Count the votes on the basis of the statements of poll. That's all.
Okay. And Mr. Arjun has said, Senior, that that basically opposition elements, and I think by that he means that they are contesting parties to the election except the APNO AFC, that you basically disrupted the process and thus thus the RO was unable to complete it. And I had taken pains to point out that the process was twofold. One was the verification of the ascertainment, which is the word used by 841. That ascertainment process was never interfered with or obstructed, but it was when he was ready to declare a result without doing that process that eruptions of voices came out. Your comment?
Well, look, the Region 4 office at High and Hatfield Street was on television all day. The entire day, the area was on television. There was no disruption, there was no violence, there was no, nothing of the sort went on. When the returning officer came and said that he is making a declaration of the result, and everybody knew that the votes were not counted on the statements of poll, there was an uproar. And then he went upstairs in secret and made the declaration. So there was an uproar, as the returning officer deems to be such other persons the returning officer says that should be present. So it's not an issue for the APNO or the PPP or ANOG or anybody else. It's an issue for the returning officer. He's the person with the authority, not the police, not somebody from Congress Place or Office of the President or Freedom House for that matter. It's the returning officer.
Okay. Thank you for that. Gentlemen, we want to wrap up our show now and to let me restate to the viewers out there what has transpired today. We were hoping to get a couple of the other attorneys who would have been in court to appear, but they're all busy with their relative parties, political parties, to discuss strategies going ahead. Because remember, viewers, time is of extreme importance. So Madam Chief Justice stands out very, very tall over the current situation in reminding the attorneys that there is no time to waste. Work through your weekends, work through your holidays, and be prepared to go late on Tuesday. So Madam Chief Justice has said that she had made a decision today that yes, the court has jurisdiction and will listen to the matters in front of it starting Tuesday afternoon. Both sides have up to, I think, 1:30 in the afternoon to present their affidavits to her. Mr. Boston has up to, I think, 9:30 in the morning, and the PPP has asked they will get up to 1:30 in the afternoon if they need to respond therein. But viewers, Tuesday, the court is expected to be very proactive in assessing whether 841 specifically would have been adhered to in the processes of GECOM. Mr. Arjun, I'm going to come to you first. Your final comments on the happenings. And viewers, on screen you are seeing muted, but this is a live video of the protests of people in Toronto. Yesterday we had New York, This is Toronto, where they're calling for the process to be followed and for election declarations to be of a free and fair and a good process, legitimate process. Mr. Arjun, your closing comments, sir.
I look forward to a just and fair conclusion of this controversy. I believe that we are blessed with having a Chief Justice who is capable of reading our constitutional history, reading the present law and applicable cases, and making a sound decision based on what is before her. In the meantime, I just hope all of Guyanese are patient, and more importantly, when that decision comes down, that we respect the decision. We have had some problems, and if we're going to build a society, we need to recognize that sometimes, as the Chief Justice said, decisions might not be liked, might not be favorable, but we have to respect them. And as I said, I don't necessarily like her entertaining the case, but I see a legal basis for her interpreting the Constitution to invoke the jurisdiction of the High Court. So I just look forward to a sound and just conclusion on Tuesday.
Thank you. And Mr. Arjun, thank you so much for joining us. We really appreciate your comments and, of course, your thinking with regards to the process. Mr. Lala, your comments, sir, as we await Tuesday's happenings now.
Yeah, I adopt everything that Mr. Arjun has said. I think he has put it very well. I felt very happy today listening to the Chief Justice. I think she has total control of the matter before her. She seems to have the temperament for this type of matter, bearing in mind the amount of public attention that is focused on the matter. She has shown that she's prepared to give both sides a fair hearing, and I think that is very important if we are to ask the country to, abide by the ruling that is to be given. It's important that justice be seen to be done, and I have full confidence that with this Chief Justice, based upon what I've seen already, that justice will be seen to be done, and we look forward to Tuesday's hearing.
Thank you for that, Mr. Lala. We do appreciate your coming on this show to kind of, explain
You're quite welcome.
Your thoughts, and we look forward to you joining us again, sir. We would love to have you
Same
again.
here.
Yeah, we would love to invite you from now for a Tuesday evening discussion, hoping we can have, even if it's 8 p.m., to have a look at
Very
what
well.
would have come out of the courts. Mr.
Then I'll have to put aside time on Tuesday to make sure I look at the proceedings.
Thank you, sir. Senior, your
pleasure.
closing comments, sir.
Well, I agree with the sentiment which has been expressed. I want to say that the Chief Justice is highly respected across the board, and I think the decision will be accepted by. Hopefully, the decision will be accepted by all. I want to call for peace, to make sure people stay in their homes, even though passions are running high. They should stay in their homes, and both major political parties should caution their supporters to expect anything. Somebody has to win and somebody has to lose, and therefore all political supporters should, be prepared to abide by whatever the result of the judgment is, and if the Chief Justice orders that the votes be counted from the statements of poll, that whatever those results are should be accepted. Now, I don't know, this matter might go further. We don't know yet, but we have to wait and see what will happen. I need to point out that the United States has issued a statement saying that whatever the results of the court decision, the government will not be recognized on the basis of results that do not emanate from the counting of the ballots, from the counting of the votes based on the statements of poll. So I just want to draw that to the attention of everybody so that we're not over yet, quite apart from whatever the court rules. There is that the United States has said that, and many other countries might follow. Thank you very much.
Thank you very much, Senior. To our viewers out there, we are privileged to have had Senior Counsel Mr. Ralph Ramkaran, Mr. Larry Lala from Trinidad and Tobago, and of course Mr. Derek Arjun from New York joining us here tonight. Let me remind you all that the Madam Chief Justice's decision was handed down today, primarily saying that the court has jurisdiction into the matter. And in so saying too, she has reminded all that the injunctions remain in place, remain enforced. That is, GECOM cannot proceed with declaration of any results, unless and until the court now listens to the rest of the matters and make a determination whether due process would have been followed per Section 84(1) and other relevant sections of the law. Ladies and gentlemen, let me remind you that GlobeSpan, Nohar Singh, Devin Bisoon, and all the people working behind the scenes are working hard to ensure that you get these live coverages. Please support us by liking our Facebook page, and also please stay in touch from wherever you are. Do some prayer for Guyana, and to my brothers and sisters all across the length and breadth of Guyana, do not hate. Please say no to racism, and please adhere to a non-violent future. We don't want any violence. We don't want to hate anybody. If it's anything, let's question due process, not the people of this country. Brothers and sisters, have a great day. And tomorrow is holy. It's the Pagwa celebration in Guyana and elsewhere in the world. Have a wonderful Pagwa. Happy International Women's Day to all the women out there. Much respect and love to you all. Have a great day. Goodbye now.
Thank you.
Thank you.
Is they're pushing the people to fight, to kill, to burn, to destroy. And when they're done, they, as the leaders, will have nothing. They will not be able to even use what is left. But the people are going to be the losers. And you know what? This is not, I heard Mani Singh saying, this is not about Indians and blacks, my brothers and sisters. This is a Guyanese event. And it is because of what is going on in Guyana that we are here. It is because of what I did in Guyana that I am here. But you need to understand a couple of things. First of all, CARICOM did not say anything in the no confidence motion. But the entire CARICOM nation, the Prime Minister of Barbados spoke in favor of what is happening. CARICOM, the OAS, the American Ambassador, British High Commissioner, Canadian, and the EU, and the Carter Center. They cannot all be wrong. They cannot all be wrong. Can they? Now, why is it that everything is pointing towards Granger and team being correct? Something has to be wrong with that. And you heard just now that Mingo was sick. Mingo was not sick. Here is the next thing. If, as they're saying, the chairman, Claudette Singh, was locked in the room, Claudette Singh never screamed for help. She never strapped the door to say, come and get me out. And there was one lady in there with her only. What kind of kidnapping was that? And then when you have the bomb scare, you know how brave GECOM people are? They really love you. When they had the bomb scare, they cleared the place and they did not leave. They weren't worried about bomb. So that is what you're getting. My friends, my brothers and sisters, we are here not to fight with anybody. We are here to make a point, a very solid point. We are Guyanese. We have relatives in Guyana. We love the country. We want only what is good for Guyana. And that is what we need help, and I say help from the Canadians, from the Americans. Some of them, if you watch your Facebook post, you'll see some of them are saying, why is it America must come and tell us what to do in our country? There is a need. America has what you call a big brother policy. There is a need because who stopped Granger from continue running office? When they dissolved Parliament, Karen Cummings was still Minister of Foreign Affairs. When Parliament was dissolved and the elections done, She's still minister. Imagine that. When Parliament is dissolved, there's no seat in Parliament. Nobody's a minister, but they were still running things and signing contracts. Those contracts will be ripped up and have to be ripped up. They are bullies. That's what they are. And now, all over the world. Last night there was a raid by Buxtonians in Bar Settlement, and you know who was chased out, right? The Buxtonians went to Bar Settlement to pick fight, and they had to run for their lives. But that can only cause bloodshed and cause harm to people. That is what we need to diffuse. And I will call now. I hope somebody's taping this. Send it to that fat slob. He is the Prime Minister, and he's still Prime Minister Moses Nagamutu.
The dog! The dog!
And Comrade Ramjatan can defuse this thing. They need to stand up now and say they're no longer supporting Rangers. If they don't do that, we're in trouble. Thank you. Alright, we are not leaving. We are moving over today. Alright, let's do the announcement now.
Thank you, Charandas. So, brothers and sisters, so we have instructions from the police because our crowd has fallen to far more than we expected. Let me tell you. When this event was organized, all the organizers thought we are expecting about 250. I told the police not more than 350. Some estimates are saying we are 1,000 strong. I want to thank you very much. So, the sergeant, the police, Toronto Police is going to be escorting us, and we're moving over to University Avenue. The demonstration, the rally continues. So please follow instructions in a very peaceful, mannerly order. Respect the other pedestrians and do not prevent them, do not block traffic. Thank you very much. So, can we have the police start instruction?
Fellow Guyanese, we'll be moving along University Avenue, and the police is of Toronto.
Where is it? So where is it?
In front of University.
So can we proceed west on Queen Street towards University Avenue, starting immediately? Thank you very much. Thank you.
We appeal to you. No fighting, no argument, peaceful protest. We are Canadian Guyanese. We are appealing to you. Please proceed peacefully along to University Avenue.
Omar! Anderson!
Watch you. Good.
You watch me?
Are you going for some?
Yeah.
Alright.
We can't find your uncle. When you
I think it's the markets.
Thank you. Hi.
It's my girlfriend.
Oh, sorry. Oh, nice to meet you too.
No.
You never tell me.
Bijo Tato. Bijo, yeah.
Oh! I know that. I never see it.
Oh, okay. Huh?
Nice family.
Yeah. All right.
See you. Yeah, all right.
Like this.
Unless if you have a permit or something.
So here we have to move. Here we have to move because our crowd is too big. So we have to move and go to a bigger space.
Hey, so like
Ranger must go! Ranger must go! Ranger must go! Ranger must go!
Ranger must go! Ranger must go! Guyana.
Our home and native land, so dear to me than all the world. I see sun slash and splash more.
Oh my god, that's not on my video.
The great Atlantic flowing for a fury. Oh, Guyana.
Oh, he didn't come. I'm gonna bring that. Yeah, I dropped him off. He's not into them things.